Hi, welcome to the Divorce Couch. My name is Simone and I'm the divorce coach based in Germany.
Hi, my name is Salma and I'm a divorce coach based in London, UK.
And hi, my name is Claire and I'm a divorce coach based in Northern Ireland.
And we have with us a professional. She is a specialist in family law, and it's Silvia Katzenmaier, who we invited to the couch today. Welcome to our episode, Divorce Matters Related to Children.
Yes, thank you very much, Simone.
Thank you. Thank you. So we thought, we give you takeaways, and we thought it's about time that we bring in some facts. Our work is very often dealing with emotions and how we handle emotions, but there's also a factual side to divorce. And very often, if a divorce goes wrong, it is either to do with money or it is to do with children. So we decided to give ourselves the pleasure of having you, Ms. Katzenmaier, on the divorce coach, and we have 5 questions prepared, and we hope to give our viewers some clarity and potentially help them with their agency by giving them more responsibility by looking into the facts. So before we begin, I'd like to introduce you, and I've done a little bit of research. So Silvia Katzenmaier is a specialist in family law. She is specialized in German and international family law. She is the member of the International Academy of Family Lawyers, IAFL. She's also the author in a book called Ausländisches Familienrecht, International Family Law, the chapter French Family Law, chapter Luxembourg Family Law by the Beck Verlag. She is the author of the chapter Division of Property and International Family Law in Maurer, der Ehevertrag in der anwaltlichen Praxis. It's prenuptial agreements. And it's published by the Deutsche Anwalt Verlag. She is she is a member of the German Bar Association, the Working Group Family Law of the German Bar Association, Working Group Inheritance Law of the German Bar Association, German-French Lawyers Association, Working Group Psychology and Law of the Regional Appeal Court in Saarbrücken. And she is a trusted lawyer of the French Diplomatic Representation in Saarbrücken and a trusted lawyer of the International Mediation Center for Family Conflict and Child Abduction. The short form is MIK, M-I-K-K, in Berlin. And she is a member of the Lawyers in Europe focusing on parental child abduction, LEPCA.
Wow.
I don't think we could have a better guest.
That is quite a resume.
Isn't it?
When it comes to matters related to children. I think what we all know is that terminology is very often thrown around when we talk about divorce. And I think in order to have clarity, and whether you, depending on where you live, if you're self-represent or if you're approaching a lawyer, I think it is important to know when it comes to child matters, what is it that you want to have more clarity of? So I would like to begin with the first question. There is custody and there is care and control. And I think there are quite similar terminologies in each country. And I would like for you to clarify the rule of thumb, what it is and why it is so important to know the difference.
Yes, it's a difference between both because parental care, or also called custody, is the right to make the important decisions for the child. For example, moving to another place or moving to another country, enrollment at a kindergarten or at a school or healthcare. And the care and control concerns only the smaller day decisions of a child's life. These include taking care of the child's daily necessities like food, for example, transportation, bedtime arrangements, how long they can watch TV, and also what to wear, also the small decisions. So this is the everyday care of the child. This is usually exercised by the parent with whom the child is living, where the child has his habitual residence. And it is very important to know the difference because in order to know what a parent may decide alone. For example, if a parent is thinking, I can decide alone when I'm moving to another country, and this is a question of custody, then you have as parent a problem that this constitutes a child abduction under civil and under criminal law. And you will have problems in court proceedings if you are taking your child from one country to another because you think you can do it. Because that is not a decision of daily life, that is a decision of custody. And in custody decisions, the other parent has to agree.
Oh, that's very clear, actually.
Yeah, could I just ask one additional question off the back of that? When we're talking about taking the child out of the country, are we referring to moving to a different country, or does that also include going on holiday or sort of visiting relatives?
So moving to another country is always a question of custody. So the other parent has to agree. If you are only visiting family members, this is a daily decision, so you can decide this alone. If you are planning a holiday, it depends. If it is in a country which is dangerous, for example, the other parent needs to agree. If it's only, for example, in a European country, that's also a decision of the daily life. So you can decide it alone if it's only for a holiday, but you can't move with the child to another country without the consent of the other parent. If you have joint custody.
Yeah. May I just add, because I think it's only when I got divorced, I realized I need to have a consent letter because, you know what, depending on, you know what, the person checking the passports, there might be the question, you know what, are you allowed to take your child out of this country? Yes. And I wasn't aware of that when we were still married because I was never asked. But then sure enough, with the divorce, we had been asked. And you know what? It is not always easy on the child because then they turn towards the child and said, you know what? Are you going on holiday? So they're really trying to figure out if this is a legitimate decision or not. So on the side note, when you're divorced and you're taking your child out on a holiday destination, I think, you know what, it is good to check out your local or regional, what I call it, rule of thumb, how they deal about it. Because I think in Canada and America, even in South Africa, it needs to be notarized. So it's not just a letter, it needs to be notarized. So that's very important.
It hasn't to be notarized in Germany, but I think it's important that you have a proof that the other parent has given his consent, because if you have perhaps a discussion when you're on holiday and he's saying, I have never given my consent, then you will have a problem because you have to prove in a proceeding about child abduction that the other parent has given his consent.
Okay. What can I ask you?
Nothing in written, this can be really difficult.
What would constitute proof?
When he's giving you a letter in which he's writing, I give my consent that the other parent can move to another country. And if you want to travel with the child, it's also important to know that some flight associations like Lufthansa, for example, they are asking for a paper, for a proof that the other parent has given his consent that you can travel with the child to another country.
So and is there an age limit on this consent?
18.
18. Okay.
The child has 18. Yes.
Okay.
Well, for a minor child, you always need the consent. But to know about child abduction, a child abduction is only a civil child abduction when a child has an age until 16 years.
Okay. I'm now quoting something I found out to talk about what we hear over and over again, which is called the best interests of the child. The aim of custody is the appropriate care of the child, while the right of access explicitly refers to contact between the child and the parent. However, both have the common goal of promoting or safeguarding the best interests of the child. On January 31st, the Australian Labor government released a draft of the Family Law Amendment Bill 2023 to amend the Family Law Act from 1975. And in a statement, Attorney General Mark Dreyfus said, The reform seeks to prioritize the best interests of the child and address criticisms that the family law system is slow, expensive, and traumatic for families. So could you, because it is something I hear over and over and over again, what, from your point of view, is the best interest of a child? And is it right to have a terminology under which we go by when we go to divorce with children?
Yes, in general, it is the best interest of the child if the child is able to maintain an equally good relationship with both parents after the divorce, which is very difficult in some cases. In order for this to work, it is very important that we have, if there are difficulties concerning contact or custody, that we have, if we introduce court proceedings, a very quick date for a hearing. In Germany, we have this legal situation that the court has to fix a date for a hearing in child matters in a space within 4 weeks after we have filed for custody or after we have filed for contact. The problem that we often have in these proceedings is that we have long-term proceedings because we often need an expert report in these proceedings, and this takes often between 6 and 9 months, which is a very, very long time. The court always tried to mediate between the parents, what is really important in this high contentious family matters, but this is only possible if the parents are also willing to cooperate. That's a problem that we often have. And I think it is very important that we give the parents offers for a free mediation service very quickly in the proceedings to avoid that we have an escalation of the discussion and to avoid that a child will lose contact with one parent.
I know we did speak to a mediator. It was a contact from Claire recently. Mediation is nothing in Germany, for example, we do instantly. So are you saying it would be actually something to go by the best interest of the child, that mediation is always something that parents should go to?
Yes.
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 See, over here with mediation, you have that both parents are interviewed, and some families are deemed not suitable for mediation at this time. So mediation, that's the government mediation. Now you can always employ private mediators, but some families are turned down because of a criteria that they use, because they feel that at this time it's not in the best interest of them to work with this family for whatever the reasons are. So sometimes here mediation is actually removed, even if one part or both want it. So there's a screening that happens.
What do you think about that? Do you think
the problem is that the court can't force the parents to make a mediation? That's something which the parents can decide if they want to make a mediation or not. And if one parent is refusing, you don't have the possibility as a judge to order that the parents have to make a mediation.
Yeah, I had a client there recently, and I was explaining to him when he was talking about, well, this is in the best interest of my children. And I said to him, this is your perceived best interest of your children, because your partner has her perceived best interest of your children, and they're not the same thing. And this is something that creates a big wall between people, because there's almost like a rightness of, but this is the best interest of the children, which is why this question, I think, is so interesting, but it's so emotive, because I was trying to help him to see that there was another side to this, and it was somebody else's perspective, and his perspective is not the only one that's on the table. And then there'll be the judge's perspective, and everybody has different glasses to look through.
But I think the problem is that the parents often can't distinguish between the parent level and the level as a couple. So the problem is that they put their conflict in the foreground and they lose the focus on their child. And that's the problem in many proceedings, because they don't see that if you have a child, you always have to work together as parents. Also, when you have a separation, because the problem is your child will grow up, you will go to the wedding of your child to celebrate perhaps the wedding of your child. And this is difficult as parents, that both parents can come to these to a wedding and to celebrate it if you don't have a respectful relationship as parents. And if you have long-term proceedings, I can say my experience, it's not possible to talk with each other after 5 or 6 years of proceedings.
Yeah.
Very difficult.
It's the difference between putting your children at the center of your divorce rather than in the middle of your divorce, because what you don't want is for them to be pulled in different directions. You want to be able to work together in their best interest. But like Claire said, sometimes emotions can sort of hinder that sort of, I think looking from the outside, it's much easier to sort of see how that would work. And I think that's where mediation comes into play. Like Claire said, is to be able to give an outside perspective when you're in it, the emotions are sort of taking over and you're not able to sort of see outside of, whatever emotion is happening at that moment in time.
Yeah.
Yes.
Which leads me to the next question, because I kind of want to immediately ask you, Ms. Katzenmaier, what you suggest. Is it mediation? Is it potentially something else? But let's go back to the situation. Something is really stuck. So both parents do not talk. I will today not make a decision whether it is both or whether it is potentially only just one person who is stalling arriving in the future. But what we hear very often is parental alienation. I know that you, with the International Academy of Family Law, have recently just talked about parental alienation. What I remember when I researched during my own divorce, there is something else which is called estrangement.
Yes.
Could you please elaborate on that and how that is part of a divorce and makes things worse and what it means in its consequence?
Yes, we have very often this problem of PIS and family cases. The problem is when a couple breaks up, in the grief and anger over the breakup, people often try to hurt the other parent. And the easiest way is through the children. Often they also have fear to lose, after they have lost the partner, to also lose the children. So they are trying to hurt the other parent. And that's easy by the children. So they are influencing and manipulating the children. And they want that the children lose the contact to the other parent. So we often have this problem. Children are saying, perhaps then after a contact with the other parent, oh, I don't want to go to him. His breakfast is a little bit funny. I don't want to visit it, which is not really a reason not to visit the other parent. So they also are finding some arguments why they won't visit the other parent, which are not really arguments. So they're saying, oh, he's always driving by car very fast, I don't want to visit them, something like this. So we often have this problem of PIS and the proceedings, and the court is always asking for an expertise in this kind of proceedings. So the expert has to verify if there's a problem of PIS, or if there is really a reason why the child don't want to visit the other parent, or if the child is manipulated by the other parent. So if the child is manipulated, the expert has to verify if it's still in the well-being of the child to visit the other parent, and has to verify if we can make supervised contact to rebuild the contact between parent and child. And the court has also the possibility to withdraw a part of the custody from the parent who is manipulating the child. And the court, if the parent who is manipulating the child is asking for spousal maintenance, the court can also withdraw the claim of spousal maintenance if the parent is manipulating the child. But in my experience, the court could make more in this kind of cases. And
what do you think would be maybe more
to use these instruments? Because we often have the situation that we have an expertise, and the expert is saying the child is manipulated, and it's not in the well-being of the child to have contact with the other parent because this is stressful. for the child. The child has a very strong binding with the parent who is influencing the child against the other parent. And then the expert is often saying, but you can't withdraw a part of the custody because it's better for the child to stay with the parent who is manipulating because he has lived with them for a long time than to change to the other parent. And in the practice, this is often the case that we don't have then context after the proceedings, that we have to stop context for some times. And if you have to stop the context for 1 year or for 1.5 years, it's really, really difficult to rebuild again the contact between parent and child.
Now, I remember there is this manipulative behavior, but then sometimes it's the own behavior which basically estranges one parent from the child. So I understand that it can be abused in order to hurt the other parent, but then there is that behavior going back to something more complex, something difficult. There is either the manipulation on one side or the wrongdoing on the other side, which really, I mean, what do you say? Kind of like factually really influences the child. Right, but there might be abuse. How is that then dealt with? Because I know that it is never okay or never good to go in with diagnosis. So I think it's important to tell our viewers, don't go and tell the judge, there is this parental alienation. So how do you handle that if there is something which is not working and there should be precautions in order to protect the child?
So if one parent is abusing the child, that's not a case of PAS. That's clear. PAS is only if one parent is manipulating the child. If there is a reason why the child don't want to go to the other parent because he's abusing the child, then you have to protect the child. That's a totally different situation.
Mm-hmm. Now, abuse is no longer only just the physical abuse. What if is that a thin line?
Also psychological abuse.
Yeah.
Yes.
So
yes.
That's not considered PAS then?
No. For example, if the child is going to the other parent and the other parent is always telling the child, your mother is a bad mother. She's doing false. She's not a good mother. She doesn't take good care for you and all that thing. That's also an psychological abuse of the child, but that's not a PAS because PAS is only if the parent with whom the child has his habitual residence is manipulating the child against the other parent. Okay. If the other parent is abusing the child physically or psychologically, it's not PAS.
Okay. Okay.
So this is,
and it's different. If you have a parental alienation syndrome, you have to protect the child from the parent who's manipulating the child. But if you have the situation that the other parent is abusive, you have to protect the child from this parent. So this is a totally different situation.
Mm-hmm. Okay.
Yeah, it is all, a lot of that is still very complicated, isn't it? Some of it's very subtle, and there's a lot of dynamics that go on under the surface. It would be, it's not straightforward, so it's not finding out what's factual and what's true and what's going on, and that's a complicated situation.
Mm-hmm.
That's the reason why we need an expertise in this kind of cases, because we need an expert who is saying to us, is the child manipulated? Has the child made a bad experience with the other parents? So for this reason, we really need an expert in this kind of proceedings.
Well, leading on from that, could I ask you about interviewing children in court? What sort of ages does that become appropriate, or would it be that a child is interviewed but not in a courtroom? And what age is deemed as appropriate to bring the child into part of this proceeding for information?
This is different in the different countries. I can say in Germany, we are beginning to talk with the children with an age of 2, which is very, very early because they can't say something about the situation.
Wow.
But yes, but the court of the judge has to hear the child beginning with the age of 2. That's mandatory. That's obligated in Germany. So but I think in the end, it's good because you are not handling a case about an object. As a child, you are deciding about the future of a child. And I think it's also important for the judge that he have seen the child at least for one time and to have an impression of the character of the child and to know something about the child, to try to talk with him, to try to understand the feelings and the character of the child, because he's making a decision about the child's future. And in Germany, it's if the judge hears this, the child, they can also, it is only in a room with the judge and with the guardian ad litem. So the lawyers are not present and the parents are not present. So the child is alone with the judge and the guardian ad litem. And the judge is then, after the hearing of the child, he's reporting to the other parties what the child has said, but the other parties are not present when the child is heard.
That is so much responsibility.
Yes, it's a lot of responsibility, but I think it's important that the judge can see the child because it's difficult because you have two parties, they are telling different stories. You don't know the child, you don't have any idea about the character of the child, if the child is in a good condition or not. And I think it's important that the judge has the possibility to see the child before he's making a judgment.
Mm-hmm.
And the thing that I picked up on as being really important is the child is a person.
Yes.
Yeah. It takes it from a name on a piece of paper, and it's a person, and it's a person who has emotions and feelings and a future and all sorts of things, and it really takes it to a different level by way of personalizing it into I think it takes it to a different dimension actually.
Mm-hmm. Yes, and if you have a judge who has experience in family matters, they are often saying, I have looked on the floor before the hearing if the child were going to the other parent, if they wanted to go to him, if they have refused to go to him, because this is saying a lot to the judge. If one parent, for example, is saying the child is refusing contact, and you have the situation, the child is seeing the other parent on the floor before we have the court hearing, and he's running to the other parent, and then you see it's not the truth.
Yeah, I suppose they're looking at a lot more than just what's on paper. Then they're reading body language. They're looking at the expressions and the interactions. Mm-hmm. Wow, that's
like us, because when I do my calls with my clients, I like to see them. So whether it's on Zoom or whether it's in person, because it's the non-verbal, unspoken body language, facial expressions. Those are the things that are unsaid that tell me so much more information other than the words when I ask a question.
Yeah.
It's almost like shooting blind in some ways when it's over a phone. It's just not the same.
And I think what can be important in these situations is that just because the two people divorcing have a fraught relationship, that doesn't in any way mean that both parents have to have that fraught relationship with the child. And I think sometimes the parents, they're making decisions based on the relationship they have with the other partner, not necessarily the relationship that both partners may have with the child, which, in lots of cases is completely different because they don't, it's a completely different relationship. So this would give, the professionals the opportunity to see those individual relationships rather than how each partner perceives that relationship based on their own experience.
Yeah. So to bring it to a close, because it's gone by so quickly, is there anything with your expertise, with your experience that would be really beneficial? I have an idea, but I would love you to just basically tell our viewers, what from your point of view, bearing in mind is the best interest of your child, what is really, really helpful for them to take away from this today?
I think it is helpful to first look for a lawyer who has experience with high contentious family matters, because it's a difference if I only make contract law or family law, and you have to have experience, and a lawyer who tries to mediate in this kind of proceedings and to accept mediation, because it is for a parent who has a separation, it's always difficult. He is emotional and he's hurt, and that's always difficult for them to judge what's the best solution for the child and to focus on the well-being of the child. And it is so important that the parents cooperate, because you only have a divorce as a couple, but not a divorce as parents. You will stay parents for all your life, and that's important. And you have to look that you don't destroy the bond between the child and one parent, and to make really, if you are feeling that this will be a high contentious divorce, that you are making quickly a mediation. And it's also important that we have a free mediation service, and a good free mediation service by specialists, because we have the problem, we have some mediation services which are expensive, and you always have couples who can't pay this. And it's important that they have the possibility to make a mediation, because this often helps to de-escalate the situation. And it's always better for the parties, because it's very stressful for the parties and for the child if you have proceedings for 5 or 6 years, because you are always in this divorce proceedings. You can't finish with that. And it's so important for the parents and for the child to find really a peaceful solution and an agreement in this kind of proceeding.
So to just add, I love the idea to look for a solicitor who has experiences with child custody matters. What would I look for in a mediator? Because I know that in Germany, they come from different backgrounds to go into mediation. Is there anything from your experience where you think, it should be maybe somebody who has some social background and is a lawyer, or what would you say, what to look for in a mediator there?
I think it's important to choose someone who has a psychological or social background, because the lawyer can consult concerning the legal things, but it's important to have someone who can de-escalate conflict a little bit. We have a good mediation service in Germany for international custody conflicts, but it's difficult if you are looking for a mediation service here. You only have a free mediation service, for example, by the German Welfare Office. But then we often have the problem, we are here near to the French border. If you have one parent who is speaking French, this will end because nobody is speaking French then at the German Welfare Office. So you don't have the possibility for a free mediation service. And if you have a German couple, you have also the problem that they often have only a time space every 3 weeks or once time per month. And that's not often enough. Normally, when the conflict is escalating, you need very intensive mediation at the beginning, so at least one time per week. If you don't have a mediation for 3 or 4 weeks, so this is always a little bit difficult.
Do I also hear you say, this is my personal interpretation, this is also a shout out to basically the government, to help divorcing families, to help them go to places which keeps the family out of court, which clearly we don't have enough of in Germany. I'm not so sure how it is in Ireland or in England. Is that what I'm hearing, to really invest way more funds to just provide splitting families to keep the...
Yes, absolutely.
Yeah.
I think it's cheaper for the state than to have all these proceedings and the child matters, because we have a lot of proceedings and conflicts with child matters. That's the problem. If we are asking for an expertise, we don't have enough experts. Actually, we are waiting for an expertise 6 months, 9 months until we get an expertise, because we don't have enough experts, because we have so many cases of conflictuous child proceedings.
That's very difficult, isn't it?
Yes. And if you have the situation that you don't have a contact between a parent and a child, and you are waiting 9 months for an expertise for a child, this is such a long time. So it's really difficult after this time to rebuild a contact.
Yeah.
That was, I think, wonderful, interesting, and insightful.
Absolutely.
With you.
Thank you so much
for your time. And what I've heard, because I have had or experienced an international divorce, I would love for you to come back at one point. And I'm pretty sure in our globalized world, there's many, many cases, and there's maybe many more things to say. So look out for this space for a new episode in the near future, hopefully. Until then, like, subscribe, comment, and thank you very much for giving you the time, for giving us your time. I hope we could support you in on your journey to make the best decision for your child.
Yes, thank you very much. You're welcome.
Thank you very much, Silvia.
Thank you.
Bye.
Okay, bye.